want me to put that on my todger?
Harry's wife. Invoke the fifth. I turned to the Mirror with an article by Oliver Pritchard Jones and Paige Freshwater, which leads with the headline, Harry's wife and Harry could copy Trump and invoke Fifth Amendment after sister sues, says lawyer. Samantha Markle is suing her half-sister, Harry's wife, accusing her of ridicule, contempt and disgrace for various comments she has made about her. But the Duchess could end up invoking the Fifth Amendment if called to give a deposition, claims an expert. Prince Harry and Harry's wife could copy Donald Trump and invoke the Fifth Amendment if they are called to give a deposition, a leading lawyer has claimed. Samantha Markle is currently suing the Duchess of Sussex, accusing her of ridicule, contempt and disgrace for various comments she has made about her. The lawsuit, of course, is a threat to Harry's wife's control. Earlier this month, a Florida judge refused a stay of discovery in the defamation lawsuit filed by Harry's wife's half-sister against the Duchess. That, of course, would amount to a dose of challenge fuel in the direction of Harry's wife threatening her sense of control because the judge hasn't granted something that she wants. This could potentially leave Harry and Harry's wife having to give depositions, an out-of-court testimony a witness gives under oath before an officer authorised to administer oaths for use later in the proceeding in the case. Nathaniel Mack, a lawyer who has conducted hundreds of depositions during his 20-year career, told Express.co.uk that while depositions can be like torture and last for hours, Harry and Harry's wife can go no comment to all of the questions. A video shows how Trump refused to answer any questions during 4 hours of questioning as he invoked his right not to self-incriminate a whopping 400 times. Now, of course, each question that was posed towards Trump is a threat to control, it's challenge fuel, and therefore his narcissism caused him to respond by invoking the fifth as a means of rejecting that threat to control and nullifying it. Mack added, the plaintiff's counsel has requested depositions of both defendants to take place before any motions to dismiss are considered. Depositions can be seen as a form of torture, especially for high-profile individuals who may be asked to disclose private information. They can also be a test of one's will and stamina. High-profile cases involving Governor Cuomo and President Trump involve 9 and 11-hour depositions. But if Harry and Harry's wife are forced to sit for a deposition, their testimony will more than likely be limited in scope and reveal few new details. This will be more of a procession than anything else. Now, of course, one thing that arises from this is the inference that is drawn from the fact that the person has refused to answer on the basis of self-incrimination. Of course, they don't want to open themselves up to further proceedings which might be based upon what they have said, but of course it's invariably the case that people's minds go to this setting. If you've nothing to be afraid of, then you'd explain yourself. If you've nothing to hide, you will explain yourself. That, of course, is often the mindset of many people faced in these situations. Of course, individuals have a right to lead a private life and therefore not be compelled to answer certain things. Just because you choose not to talk about it doesn't necessarily mean that you're guilty of it, but it's generally the case in the court of public opinion that people think contrary to that. They think, well, if you've nothing to hide, you'd explain that, and therefore the fact that you're not speaking up must mean you've done it. Now, of course, there are instances where such an inference is appropriate. I recall advising a client in the context of dealing with a narcissist husband, and I reviewed his deposition video, and it was interesting whereby where he was answering certain questions, he would do so where it was utilising vagueness a lot of the time to deflect from the threat to control that had occurred. So where he was posed certain questions which would cause him a problem with regard to providing an answer, various suggestions, for instance, of him misappropriating money, in those circumstances, he would reply in a vague manner, almost like a will-o'-the-wisp that couldn't be tied down to anything in particular. When he was asked about his contributions to a business that his wife had essentially set up, then, of course, he was able to give lots of detail, manufactured detail, basically unpacking things that he had done to make it look like he'd done far more. So, for instance, where one thing could be described in a short phrase, he would break that down into 6 different things to make it seem like he'd done a lot more. So, for instance, if it was the observation that you've been involved in stacking up paper, he would describe it as paper management, ensuring that the vertical was aligned with the horizontal, that there was the correct collation of a material used in the communication of the company's ideas, that there was a creation of a storage system for a material that was utilised to record happenings within the company, that he was involved in the creation and monitoring of information systems. And you see what is being done. A simple action of just stacking paper is described lots of different ways to make it seem like he had done a lot. And so his style in the deposition moved from being vague where he was threatened, and where it was something that he felt more confident in talking about, he became far more verbose. It was also the case that it was suggested that he had repeatedly engaged in particular affairs, and to that, because of the state that he was in, infidelity was a crime, he invoked the fifth repeatedly. And in those circumstances, it was evident, of course, that he clearly had engaged in those affairs, but he was invoking the fifth, not only, of course, to protect himself against criminal proceedings, but also to hide behind. But the inference was clear. The inference was clear because, of course, he'd answered lots of other questions, but not those ones. And that is one of the problems that arises. Might that be the case similarly for Harry and Harry's wife? It may well be, if they choose to answer certain questions and not, rather than adopting the blanket approach of Donald Trump of invoking the fifth to nearly everything. The article continues by explaining that Samantha's case is currently in the preliminary steps, known as the discovery stage. During this time, both sides have the chance to request information and evidence from the other side in preparation for a trial. This involves written and oral discovery. The depositions that are in question are a form of oral discovery, he explained. The case seems to have skipped the written discovery phase, as the defendants may have refused to provide the requested answers. That, of course, would not be a surprise, which is a form of denial utilised by Harry's wife to nullify the threat to control. The lawyer also expressed surprise at the minuscule $75,000 award that Samantha is suing for, and why she picked Florida. The amount she is seeking in compensation for her alleged injury is rather minuscule in comparison to her claims, he said. However, her legal team seems committed to pushing the case forward. The fact that she chose to file in Florida instead of a more liberal venue is interesting, considering the defendants are domiciled in California. Nonetheless, the alleged defamatory statements being claimed by the plaintiff seem to be subjective. Samantha must substantiate the claims in her pleadings by meeting the burden of proof set forth under United States federal law. If the case survives dismissal, it will be fascinating to see what type of evidence the plaintiff can produce to support her claims. The judge's ruling means that Samantha's lawyers will question the Prince and Duchess before July if the case continues. The deadline for disclosure of expert reports is 5th of May, rebuttal is 5th of June, and the discovery deadline is 3rd of July, according to court documents. Samantha has taken issue with comments made in the royal couple's bombshell 2021 interview with Oprah and the 2020 book Finding Freedom. Might it be the case that Harry's wife would invoke the fifth? Absolutely. It would be a form of denial, which, of course, as you know, is the first line of the twin lines of the narcissist's defense. Of course, inference might be drawn from it in the court of public opinion, but the fact remains that this court case is a thorn in the side of Harry's wife. It continues to threaten her need for control, and she will continue to do whatever she can to dismiss it and slow the case down. I'm H.G. Tudor. Thank you for listening.